That's everything that I looked at, as well as any authority cited therein, statutes, case law, or otherwise. You don't have to repeat yourselves, but you certainly can if you would like. I have the balance of all day today. I take a lunch break between 12:30 and 1:45. I can likewise give you the entire day tomorrow. I won't limit either side to present whatever evidence, witnesses, or testimony they would like to present. Defense, I'm going to start with you, and I also did read Rutledge versus State, which is 157 3rd 830, regarding the defense motion for hearing to determine potential conflict. So, whenever you're ready, you may proceed.
Thank you, Your Honor. Rutledge and other cases, federal cases, because state court really hasn't delved into this area as much as the federal case law does, indicates that there are certain things we need to find out first of all. So I don't know if this is the hearing or you want to set a hearing, but the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, and I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Devins to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they've subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty. But she has not received any. In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year, or over a year, with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Devins, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not that has been waived up until that time, I think the case law is pretty clear. At that time, if she has charges against her, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering, under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shaden. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty, and they happen to fall before the end of Mr. Demon's trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago, we would have sat with Mr. Devins, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have been.